any part of John's body that would have touched those areas, there would be forensic evidence. If it was a sweatshirt, if he had Levi jeans on, you'd be able to, because with the rainy night, it would stick to the metal. The other thing is the metal is so thin now when they build these cars that the way the taillight shattered, it would have had to done damage, body damage. So there should be a crease in the quarter panel or there should be a dent in the tailgate. So
all right.
I think when the defense comes in, they will have forensic experts showing these things, and I don't think any of that was done. And to smash that taillight, I'm telling you, Billy, usually you got to back into a tree or
That's what we were saying.
Okay, good point, Mike. Thank you very much for the call. A quick response to that, Catherine?
I think he's exactly right. He has an area of expertise that I don't.
Mm-hmm.
So
Actually, maybe he should be called into
that's
court.
That's right. And so that's why it's important to listen to the people who know what they're talking about. So the defense and the prosecution are both going to have that opportunity to present their sides.
All right, let's go to Eric. Eric, you're up next. What's your question?
Hey, good morning, guys. So quick question, Catherine. Last week, I think McLaughlin or the paramedic that was on the stand brought up that she didn't know, I forget the people's names, the Alberts maybe, and then all those photos came out, and the defense asked, hey, can this be looked into for perjury? And the judge said, hey, yeah, we're going to do it, and then nothing ever happened from that. A, do you think she did commit perjury? And B, is there any word on the judge, going back to that topic? I'll just hang up now. Thanks, guys.
Thank you. That was a big story this week.
That was a good question.
It was. So for a little bit of background, firefighter McLaughlin testified last Friday, and the line of inquiry from the defense was relative to her relationship with Caitlin Albert, who's the daughter of the homeowners at 34 Fairview. What the testimony was that when she was asked, quite frankly, do you know her? She said, I know a Caitlin Albert from high school. The way I perceived her testimony was she knew she'd already kind of been attacked outside in the online and things like that. I think she was on the defensive. Instead of just saying, yeah, I know her, would I lie for her? Would I make something up for her? No. Instead, she mischaracterized what her relationship was. So do I think that she necessarily lied? I think she certainly minimized the nature of the relationship. Yeah. Perjury, you have to lie. There has to be an untruth. So when someone says I'm an acquaintance versus I'm a close friend, that's subjective. That's not really a lie versus.
Well, it's crazy because every time I think I have an opinion, that opinion changes, and then I say, oh, wait a minute, I didn't know that. Let's go to the talkback because they're pouring.
We have so many of them. Yeah. So I'm just going to go down. We have a couple questions for you. So I'll go with the first one.
Good morning, Catherine. My question is, don't you think it's a little odd, or why do you think that even though John O'Keefe was found outside that house, there was never a search of the house? Isn't that a little bit strange?
Yeah, they never went in.
So there was a lot of talk about probable cause. It's funny. This is one of the first things I talked about when I started looking at the case. I said, this seems interesting. Why didn't they at least freeze the house? Why didn't they search the house? Listening to the testimony as it's come in so far, granted, we haven't heard anything. I actually think they're correct in that there wasn't probable cause to search the house. You have to remember the probable cause has to be established in order to go to a judge. The police officer who's filling out an affidavit for a search warrant has to swear under the pains and penalties of perjury that they have a reasonable belief that there's evidence inside the house, either that a crime is being committed. And I'm not sure that we quite get to that point, because if you think about that, the on-scene testimony, say, for example, Karen had said, I dropped him off there. He went in the house. There's your probable cause. Okay. And then he ends up on the lawn. Instead, the testimony that we have, it actually goes in the opposite way, which is, I hit him.
Yeah, but I'm just thinking, there's a body on the ground. You knock on the door.
Sure.
Exactly.
By the way, do you happen to know the person on the ground out here? Right?
Who is he? Does he live here? Was he in the house?
Yeah.
All right, let's go. We have more.
Gigi from Somerville here. So I have a question for Karen, the lawyer. I did not hear her say it either on the tape, I hit him. But they keep saying that. But nobody has said, did she say, I hit him, period, or I hit him, question mark.
Good point.
Right, it's the inflection.
I actually think That's an interesting question because it's the defense's job to do that, and the defense hasn't asked that question. And I think because they know that what's going to be admitted at some point is the interview with Karen Reed on Nightline, in which she acknowledges that she said, "Oh, I hit him. It was preceded by a did and followed by a question mark." So they're really not refuting. It's an interesting analysis because everybody's saying she didn't say it, but she really has admitted she said it in her own words.
Yeah.
And so I think the defense is not really attacking that line of inquiry because they've essentially already acknowledged.
But
that
again, if this was my courtroom, the jury would get to ask questions. This is going well. Who have you got now?
We have one about the Canton police.
Okay, I am obsessed with the Karen Reed case like everybody else. I'm actually depressed that I have to work today because the last 2 days I've had off and I've been watching it. It's a problem. However, my biggest question is, if she is found innocent, are they going to charge the Canton Police Department or any of these people that may have been involved? I'm very curious.
So she's never going to be found innocent because that's not the standard in which our jury system works. It's guilt or not guilty. So not guilty does not equal innocent. From my perspective, when the Commonwealth charges someone like they're charging Karen Reed, they think she did it. So if she's found not guilty, it doesn't mean to the Commonwealth, oh, we're going to pick somebody else. And that's not a system we want. We don't want the government trying somebody and then saying, oh, they're not guilty, we'll try to find somebody else. They just think they haven't proved the case. Whether the Canton police will be held responsible, I think is a pretty high burden because you'd probably have to prove or at least show that she is actually innocent. I don't know that we have evidence. We have evidence that theory can lead that way, but I don't know that we have actually evidence of that. The federal investigation has been ongoing for quite some time surrounding both the state police and the Canton police. We haven't heard anything from the federal investigation, whether anybody is going to be indicted or charged, and they haven't so far. So I think the likelihood of anything happening specific to this case, if she's found not guilty, is slim.
If you don't mind me asking back to something earlier, what happened to the dog? Everybody's saying the dog disappeared. Couldn't they use the dog's imprints of his mouth and match it up to the wounds in the body?
So they did take, there was a swab that was eventually sent to, I believe it was the Bodie lab, which is, I may be wrong, but I believe it's in Virginia. And that was a big pretrial issue with the defense. That seems to have been kind of pushed aside. I think that they haven't specifically said that there was no dog DNA found on the arm, but the defense has sort of reduced that. They've stopped talking about it quite as much as they were in the beginning. So, which leads me to believe that there probably wasn't anything found on the arm. If the defense wants to put on somebody that says, an expert that says, a canine expert that says this was a dog, this was bite marks, they can certainly do it.
What about the weird story about the pool being filled in?
So, listen, the way I look at it is, it's a lot of mundane things, but when you put on the theory, in and of itself, filling a pool in or selling a house is not strange or weird, right? It's a normal course of behavior. But when you put it within the scope of, did something happen in this house that you want to potentially cover up, it changes the analysis. So really it's, I think it's up to what the jury hears, if they hear any evidence about that and how reliable they find it.
All right, we got to go. This has been an awesome topic time because it's such a hot topic in the area. I feel like we were just in the courtroom.
Thank you for having me.
Well, I hope you'll come back.
Absolutely.
All right, we'll make it for
please.
next week. I'll book you for next week.
Yeah, thank you really, Catherine. Thank you for coming in.